Welcome everybody to the 11th annual Evil Twin Debate put on by the Intellectual Property Institute at the University of Richmond. The AALS IP section has kind of joined forces with us over the last couple of years. And thank you so much to Thomas Jefferson Law School and Professor Brenda Simon and Catherine for helping us put on the event in such a close location in a beautiful room. So for those who are not familiar, the Evil Twin Debate is based on the philosophy that there are those in the IP area that have disagreements over substance, but still remain friends. And so Jim Gibson in 2006 told me that there would be this great idea to hold an Evil Twin Debate to kind of monopolize or leverage off of both of those. I told him he was an idiot, that it would never last, and we'll only do it for a year. So this shows don't listen to anything I say. So 11 years later, we've leveraged off of this, finding people who have substantive disagreements, but having a little bit of a lighthearted tone to them. And we have that today. So the topic for today is the Defend Trade Secrets Act Defensible. As you all maybe know or don't know, the Defend Trade Secrets Act was passed in 2006. Essentially, it created a civil cause of action at the federal level for trade secret misappropriation. 2016. Sorry, thank you very much. See, this is why I'm not one of the debaters. This is why I picked Orly to start this thing off. And so we're going to explore whether this is defensible or not. And so we have our evil twins today that obviously know much more about this than I do. First, we have Orly Lobel from San Diego Law School. We've got Michael Risch from Villanova Law School. And the way we will do this is that Orly will start things off. We'll give her 18 minutes to be exact to kind of present her case, or 15 minutes to present her case, 18 minutes for Michael to present his case, and then Orly 3 minutes for rebuttal. An important part of the evil twin tradition is to have our twins write the other's biography. And so we were kind of blessed that both of our twins were willing to do this. And so Michael wrote Orly's biography, Orly wrote Michael's biography. This time they asked me to read them. I don't know really what that means, one way or another. I will read them. And so here we go. So this is Michael Risch's biography of Orly Lobel. Orly Lobel is the Don Wickstein Professor of Employment and Labor Law at the University of San Diego Law School, where she has taught since 2005. As a native Israeli, Orly Lobel served in the Israeli Defense Force working in military intelligence. After having read her scholarship, her former commanders referred to her as the one that got away. Following her service, she set the Wonder Woman movie franchise back by 20 years when she declined an audition and instead decided to study law, where she graduated first in her class at Tel Aviv University and then clerked at the Supreme Court of Israel. Because Tel Aviv is not listed in U.S. News, and therefore doesn't exist, Professor Lobel decided to go to this place called Harvard Law School and get her LLM and SJD. Professor Lobel's scholarship is wide-ranging. In addition to her monographs, Talent Wants to Be Free, also known as All Your Trade Secrets Belong to Us. I appreciate that. And You Don't Own Me, also known as Don't Mess with Barbie, which I was blessed with a copy here. Right? She's co-edited an Elgar volume on employment labor and labor law and a Hebrew volume on labor and employment law. She has published nearly 50 law review articles, each of which have been read. Her worldwide presentation. This is something I couldn't claim for mine. Her worldwide presentation list would make almost anyone envious of her frequent flyer status. During her spare time between writing best-selling books, Lobel enjoys teaching in both employment law and intellectual property law. She coaches her students never to leave California for Massachusetts, lest they be ensnared in one of those nasty non-competition agreements. She also has a Wikipedia page, but one sufficiently out of date that it's pretty clear that she did not write it herself. And I'll just apologize in advance. We have a reception after this, but Orly has to be whisked away to go to a book event at University of San Diego for this, and so I wanted to let you guys know. Okay, so here is Orly's biography of Michael Risch. Michael Risch is the Associate Dean for Faculty Research and Development at Villanova University School of Law. He writes in all areas of intellectual property and internet law, but his main focus is patents and trade secrets. He's published numerous articles in top journals and is also a regular blogger. which some of us sometimes count as scholarship. He writes so much that sometimes he even contradicts himself, as can be gathered by the titles of his 2 articles, Everything is Patentable and Nothing is Patentable. In Mayo versus Prometheus, Justice Breyer cited to 2 of Michael's articles, and the justice even attempted to dissect Risch's complex state of mind, pointing to the tension between the 2 articles. That made Michael giddy. Michael is well familiar with people trying to reverse engineer his thoughts, and perhaps this is why he's become such a leading expert in data security and secrecy. At a young age, he got pushback mail for his high school valedictorian speech, which prepared him well for the University of Chicago School of Law. He started protecting information in college, running the lecture notes service at Stanford, but always asking professors for permission. At Villanova, he puts his knowledge and anxieties over leakage and hacking to use by serving on the university's cybersecurity program committee. But the most practical mileage and dollars he gets out of his vast knowledge is by being counsel at a boutique IP law firm, surprisingly not based in Pennsylvania, but in Silicon Valley, California. If you're starting your own business, he can even advise you on email encryption. In fact, Michael doesn't only advise, he acts. He's an avid computer programmer, and early on sold an encryption program he developed to a software company. So drinks are on him tonight. Okay. So now that we have our 2, we know them very well, right? I will give the floor to Orly for her opening arguments.
Thank you. Thank you, Chris. Thank you, Thomas Jefferson, for hosting this great event. Also, thank you to my evil twin. If it's not clear, he's the evil one. Michael Risch, because I've learned a lot from his work on trade secrets. So this should really be fun. And I do, again, want to apologize. I'm running to an overbooked list of events. So University of San Diego is doing a book reception for my book that actually starts at 5:30. So I have to be there, but when you all are done schmoozing in this reception, you can join our campus and come celebrate with us. I was really excited because this morning the Financial Times did a review of You Don't Own Me, and I wanted to share this with all of you because it said usually the topic of IP is such a dry topic, but in the hands of Lobel it becomes a page turner, and they don't know that it's never dry when it's in this forum. So it's so great to be with all of you. So the Defense Trade Secret Act was passed in May 2016, and in 2015 there was a group of professors who wrote an opposition letter saying that it really has a lot of issues, there's the problems with the bill, and it should not be passed. Full disclosure, I was one of the professors on that letter, and I want to make some distinctions about what it means to oppose the Defense Trade Secret Act. There are some aspects in the act itself that might present certain risks, that some language that maybe is not the desirable one. There's another kind of opposition I think that existed and still exists in what the Defense Trade Secret did not do. So problems that were always there with how trade secret litigation and trade secret law has developed, that it was an opportunity to correct, and it was sort of a missed opportunity. And there's a third aspect, which is what the passage in 2016, when we've never had a federal civil right of action for trade secrets, what does that enactment mean and signal to what I've called our secrecy ecology, how we think about the lines that we draw in trade secrets, that kind of concern that goes into how it will be signaling greater concerns with trade secrecy and with sharing of information, with leakage of information, and how it might embolden plaintiffs to make greater claims, even if all else stays the same with what the law allows. And I do want to say that some of the initial critiques that we made, a lot of us in the room and in the community made about the bill as it was first presented were actually addressed and the final version actually got better in some aspects, like the Manel effort on the whistleblowing provision and some language that was added with the concerns about whether inevitable disclosure is adopted into the act. Some of the concerns also that we had before it was passed about how much of an uptick we'll see, kind of that emboldening of just having a lot of litigation in federal courts, have also not really come to fruition yet in any really dramatic way. So Chris Seaman and David Levin had a great kind of first year data about what's been happening and how much usage there has been with the Defend Trade Secret Act. And there is an uptick. There are cases, and Michael might say, it's a small percentage relative to patent law, but I don't think that's to patent litigation. But I don't know that that's a good measure. There's been it adds another path, and it of course doesn't preempt all of the other possibilities. But I also think that just counting cases that have been filed or what we know sort of that's happening in the courtroom. I think we need to remember that it's a lot of times in this area it's just the tip of the iceberg, and we don't really see the other kinds of ways that the existence of the Trade Secret Act and everything that it signals, and again taking it in the context of other amendments to the Economic Espionage Act that have happened recently, and various prosecutorial actions and litigation developments, how we are seeing really an emboldening, and not just in bringing action in court. So the best example that I have from this week is, of course, President Trump sending a cease and desist letter to his former staff member, to Bannon, and saying this is a breach of our NDA, which is, of course, I think ridiculous in that context, but I think, again, it should be understood as part of what is going on with how we kind of cite to secrecy, and of course, anybody who knows a little bit about my work, I very much worry about how that can chill employee behavior and speech and movement. And I've already alluded to this, and I've been so fortunate to learn a lot from Rochelle and then to write a paper with her on this. Again, the Defend Trade Secret Act amends the Economic Espionage Act, but there have been a couple of other amendments just in recent years. And again, we have to understand this as not coincidental. The criminal side of the economic espionage was amended twice in the past few years. One to increase the remedies, and the other time to broaden the definitions of what is covered. And it's also not a coincidence that the same month that the Defend Trade Secret Act was passed, the EU passed a directive on trade secrets, and it really, we have to understand it as part of kind of a real government effort, a global campaign to say we don't have enough tools, enough kind of power behind behind what we want of secrecy and protecting our trade secrets. So, you know, on the why there's this global push and a greater push for a secrecy ecology, one of the things that we have to remember is that we're seeing a lot of messages that are coming from the top. So again, Rochelle and I looked at a lot of documents, government documents that are educating the public about the importance of secrecy, and we raised several concerns about kind of forgetting that cost-benefit question of how to draw the lines between information that we want to have shared and information that has to be behind walls. And we asked questions about government secrets, about the private sector, university secrets, and or university research that is now deemed secret more and more. And one of the things that we pointed out to then, again, before we go into the civil right of action, is that the rise in prosecutorial activity and the educational material around it has at least something to do with global competition and kind of the fear of losing the American dominance in innovation. So not so much the purpose of promoting innovation, but maybe stopping others from surpassing. And we see kind of that signs of xenophobia that actually I don't think we have any reason to not be fearful that will only get back to kind of building virtual walls globally and signaling certain countries and certain people from certain nationalities as being particularly dangerous. Trade secrets in general, as we all know, are in some ways kind of the neglected stepchild of intellectual property, in that in some ways it's the strongest form of intellectual property protection, with its kind of inclusive nature of anything can be deemed trade secret. And we see this with the definitions in the Defense Trade Secret Act, which defines trade secrets as all forms and all types of financial, business, scientific, technical, economic, or engineering information, including, and it's a very, very long list, whether tangible or non-tangible, or how stored, compiled, memorialized, physical, very, very inclusive list. And also the fact that it can potentially last forever. But also just the kind of profound reality that trade secret protection, it protects against not only usage, but against any knowledge. So that's really unlike other forms of intellectual property where we have disclosure requirements, like in patent, and we can see what we're creating. And so we have to remember that the more we're strengthening trade secret law, we are nearing that fear that that trade secrets will overly serve as a substitute to other forms of intellectual property, and most clearly patents. In Kiwani many years ago, the Supreme Court thought that was a really remote possibility, that it would be natural that anybody who can file for a patent will do that, and so we shouldn't be so fearful of that strong protection for trade secrets. But I think that we've been seeing, both in the push and the pull, both developments in patent law and with these passing of reforms like the Defense Trade Secret Act, we are now seeing it more as a reality. I think that both on the criminal and the civil side of things, with the Defense Trade Secret Act and the Economic Espionage Act, there was a lot of talk of why we need a federal statute, with the purpose, the examples are kind of the paradigmatic scenarios that were cited in the hearings are the kind of either computer crime, cybersecurity, or the sort of more sophisticated Kiwani, or not, the Christopher versus DuPont kind of style of economic espionage. But in reality, and I think this is very clearly shown empirically, and we know this from our engagement with the practice, that the vast majority of these of trade secret cases, both in the state courts and in the federal courts, are between employers and employees, or employers and their former employees. And the subject matters are oftentimes things like client lists and employee performance and marketing and pricing, not the kind of traditional trade secrets that we used to think about. And even if you think about the recently, just last month in the Waymo versus Uber case, kind of the court mused, well, do employees need to have a lobotomy, a frontal lobotomy, before they move on? Is that what you're claiming? Clearly, that's not, that should not be the case. The Defend Trade Secret Act did not do what it could have done, which is explain what are proper means and what are not trade secrets. So using skill and general knowledge, and even though we're supposed to know this by now, we can see this in November 2017 in the Waymo case, that it's still kind of that push of over-claiming. I'll say just a couple more things about the actual language in the Defend Trade Secret Act. So again, I think some of the fears that we cited to, like the very strong remedies, the ex parte seizure remedy, I think I'm less worried about that because we see that in practice it hasn't been, for now, really used too much, and it really requires extraordinary circumstances. But with the inevitable disclosure provision, I think that it's a little bit more mixed. I looked at some cases that even though there was a compromise in the end in the passage of the act that has this kind of fuzzy language that it does say that there would be a remedy for threat and misappropriation, so potentially adopting the doctrine, but on the other hand, not changing state law on this. Courts seem to be a little fuzzy on this. So I'll just wrap up in saying, in the end of the day, there is a potential to get a little bit more clarity. I think federal courts are thought to be a little bit more precise and cautious in the application of statute, and we have the potential to get a little bit more consistency and clarification of some of the existing issues in trade secrets. But I think there are a lot of missed opportunities, and I think that the risks exist, especially because, again, the application of these provisions really have a lot to do with the climate, the broader climate, from the very top of how we think about these trade-offs and what is secrecy and what are the purposes of secrecy. Thank you.
Hi, good afternoon. I'd like to first say thank you. Thanks to Richmond for having me. Thanks to Thomas Jefferson Law School for hosting this. I wore goatee many years ago. I tell you this because, like Evil Spock, or as I like to call him, Alternative Universe Spock, I thought about growing a goatee, but I decided not to. So if you're having trouble telling me and Orly apart, I apologize for that. I'd also like to say thank you for picking this topic. As was just mentioned, trade secrets are treated as the ugly stepchild of IP. Some would like to think it's more of Cinderella. But this is an important and ongoing debate. when I was at WVU, I used to teach the trade secret and non-competition agreement class for a colleague's employment law class, and I used to joke that in their employment book, trade secrets fell under worker mobility, and in the IP book, it falls under protection of information. And so this is an ongoing debate that's not going anywhere. So I didn't sign that letter to Congress that was against the Defend Trade Secret Act, but at the same time, I was never a rah-rah fan of the act. I just wasn't down on it either. It was more of a, this is a non-issue. And so my primary thesis today is this is a non-issue. The Defend Trade Secret Act is, you know, Uniform Trade Secret Act for the 21st century, or UTSA in federal court, etc. Now, Orly mentioned what the act does not do. I agree, it doesn't do a lot of things we might have liked the Uniform Trade Secret Act to do. It doesn't clarify things, it doesn't give more protections. But most legislation doesn't do all sorts of things we want it to do. That doesn't necessarily mean it's a bad thing. The fact that it doesn't do a lot of more harm than it could have done, I think is pretty good, because it could have done a lot more harm that a lot of people were worried about. So what I want to talk about today primarily is this notion of ecology of secrecy. Is there really an expansion of trade secrets going on? And then, if there's time, I'll mention a couple areas where I think there could be some further research. So let's start with comparative scope. There were, and this comes from the study that David Levine and Chris Seaman are doing, so I thank them for providing me a draft of their paper. There were 480 Defend Trade Secret cases filed in the first year after the Act. There were 4,800 or more patent cases. So, yes, there was a rise in trade secret cases. What we don't know is how many of those trade secret cases would have been filed in state court anyway. We don't know how many cases were filed in state court under the DTSA. We don't know how many were filed under Uniform Trade Secret Act only, but it's a small portion versus patent. And then the interesting thing about trade secret cases is, as Orly just said, it's mostly against ex-employees, which is somebody you have a relationship, somebody you know. Sometimes they are accused unfairly, sometimes they are not. But the funny thing about patent cases is almost always against somebody who had no idea the patent was out there and is like, what, me? I didn't know. And there's so many more of those cases. And so when we're talking about ecology of IP and comparative issues, you have to ask, is it the unknown, the plaintiff or the defendant who doesn't know it's coming versus the defendant who might know it's coming? Should we care more about one or the other? We should probably care about both. But comparatively, they're very different scenarios. I tend to worry more about patents in that sense. And I also think that the Defend Trade Secret Act didn't change much in that sense. But the other interesting thing about it being only employees or primarily employees, as it was before under the state law studies that we have, is we don't have this trade secret trolling notion that some were worried about. It's not like people are somehow getting trade secrets and going after them. It's people that you have a relationship with, although sometimes we know that plaintiffs are overzealous. I'll talk about that in a minute. So that's number one, the comparative scope. Number two, the Act does something really important that I think doesn't get mentioned a whole lot, which is define trade secrets as not IP. And Eric Goldman has an essay on this. I hate that provision because I think trade secrets are IP. But what calling trade secrets not IP does is takes it out of the realm of takedowns for Section 230, and that's important because once you get the trade secret and you put it online, it makes it much, much harder to take down, which means it makes it easier to spread, and when it makes it easier to spread, it makes it easier to lose. And so that actually, for things that are marginal trade secrets, it makes it easier to have dissemination, where the plaintiff can't argue that this was a trade secret, and you have to have some sort of remedy to show it really is a trade secret if you want to get it taken down. But even then, under 230, theoretically, you can't get that order. The third point, which was already mentioned, the whistleblowing is something that was done. I don't know how often it comes up, but I think that's a real benefit. If we're talking about a growth, a bear hugging of secrets, having a provision that says whistleblowing is protected and not considered trade secrecy, that's a big deal. And that is antithetical to an expansion of protection. The next point is the inevitable disclosure point. While not getting rid of inevitable disclosure, which by the way I'm not a fan of at all, the language added at least makes it somewhat in line with state law. And state law will sometimes apply things that are like inevitable disclosure, and sometimes they won't, or judges won't, depending on the state. But at least there's a chance under the DTSA that it won't apply. Of course, because there's no preemption, you might have inevitable disclosure under the UTSA. So once again, the Defend Trade Secret Act is really not really a change, regardless of how it comes out. The next point I want to make is that the incentive to file these claims, certainly in federal court, is perhaps overstated. Many states have juries that don't have to be unanimous. So if I'm a plaintiff, or I'm a lawyer with a plaintiff who wants to bully an employee or somebody else, and I want to extract a settlement, I might choose or advise filing in state court saying, look, I just got to convince 9 people out of 12. I don't have to get a unanimous jury. To me, that holds some sway. It was one of the benefits of filing in state court when we had trade secret cases when I was in practice. The next point is about the rising number of suits. One area, and I guess this is an area of further study, but I'll raise it here as well. I wonder whether the increase in suits and in prosecutions are also because it's easier to catch people in the computer age. A story I'll tell, and this will come up again with the seizure provision, was right before I started working at the firm I started working at, there was an employee who had gone to his office on a weekend. He had downloaded at the time it was like big discs and tapes, and he was going to fly to France, and they literally arrested him at the airport with this. My former partner describes deposing him while he was in jail. But they were lucky that they caught him on the weekend. They didn't have the types of firewalls and logging, etc., that you see going on in the cases today. If you read the cases today and the types of declarations, they have pretty good information about what people do. That's not to say that the information is foolproof. We had an expert once who swore that an entire drive was copied because everything had an access date, but it turned out it was the antivirus software. So that was not great. But that was a UTSA case. So the Defend Trade Secret Act wouldn't have changed that one way or the other. Which leads to a more general question, which is whether or not this notion of emboldening is a leading indicator or trailing indicator of how companies are seeing their secrecy. So is the Defend Trade Secret Act caused by the fact that people want to have more protection of their trade secrets and are looking for a way to do it? Or is the Defend Trade Secret Act a way that allows people to protect their trade secrets? So for example, in the question of people turning to trade secrets rather than patents, the Kuwani question, if we ask why would people turn to trade secrets rather than patents, the #1 answer in my mind is because you can't patent software anymore. And so how else are you going to protect it? And so you're going to have firms looking to protect via trade secrecy. And with or without the Defend Trade Secret Act, I suspect you're going to see a rise in trade secret cases. And the Defend Trade Secret Act may just be a trailing indicator of that. One last point on the harm potential. Orly didn't raise it, but I want to mention it briefly, which is the seizure provision, which really worried people. But it turns out that not many people have asked for seizures. Most of the requests are granted, and often the orders are limited to copy and return the hard drive, so it's not fully seized. And often it's for people who are caught red-handed, copying an entire computer onto a USB key on a CCTV camera. This is the type of evidence that's coming in the cases where it's granted. And interestingly, they have, at least in the few orders I've read, often involved cyber-type issues, mostly people copying stuff to Dropbox, which, by the way, is not a really smart way to misappropriate trade secrets, because there's a pretty good log of what happened. But then the plaintiff comes in and says, here's the Dropbox. But the point is, they need the seizure. They get the marshal to serve on Dropbox. It actually is serving a purpose. And so the seizure, which I think is one of the more risky parts of the DTSA, hasn't been borne out. So I'll end this part with an observation I made in 2009 in an essay that came from, interestingly, a talk I gave at ALS. It was commentary on high worker mobility in Silicon Valley. And what I said then is I think the same now, which ties into my point that I don't think there's been an expansion, which is that plaintiffs will always claim that everything was taken. The defendant is the most evil person ever. They are going to abscond, and these are the most important trade secrets ever. This is Waymo, right? And the defendant will always say, look, no, we didn't take anything, and if we did, we didn't use any of it, and you can't show that we used any of it, and we didn't do anything wrong, and we don't need a frontal lobotomy, and this is all knowledge and experience, and it's all good. This is Uber, right? And the truth is almost always, at least in my experience in doing many, many, many trade secret cases, somewhere in between. When you get to discovery, there was always something that was taken, and it's never as good as the plaintiff wanted. And so the question really, the question really is, what's the chilling effect? And so here are some areas of further study. Number one, and this is an issue from Rochelle and Orly's article, which is really interesting. Is there a xenophobic aspect to this that's affecting universities and otherwise? So I gave you the example of the person who was leaving France, or is it the fact that people who are foreign, more likely to leave the country, more likely to be out of the country? I think the jury's out on the data, but we should watch this closely. We should find out, are we going after people with Chinese surnames who live in America and never have any connection to China? I think we have done that some, right, as you detail in your article. So that's not so great. We should do more study of that and systematically to really get to the problem is it's a small sample size that we find out about. The second point of study is how much bullying is going on of employees, what's the actual evidence. And here I will say that DTSA has actually improved things, and this will be my final point. State court research is awful. It's really bad, and the state court empirical studies we had take a long time. They're not really random, they're not really robust. One thing we're getting from the DTSA is filings in federal court where we can go on to Bloomberg or Pacer or Lex Machina if they start doing trade secret stuff more, or whoever else is gathering these, get the documents, look at the evidence, and do real studies, things that were really difficult. Just like 10 years ago, it was a big deal to do a study that looked at actual patent cases, and now everybody and their siblings do it because you just go online and you get the dockets and you look at it and you see what happened. We can do that now with trade secrets in a way we couldn't do before, and I think the DTSA makes that possible, and we should not discount that. Thank you very much.
So I think it actually was kind of clear from our debate that we're not super far away in how we see the world. But I'll respond to, so one important, I think, thing about understanding whether the law that we have now is good, is right. I don't think really that the question is whether we have, how much trade secret protection, or whether we have, enough, or where is the sand line being drawn at any given moment. It really, one of the things that I think I'm concerned about is that we have to see how much harm versus how much good the various definitions that we have are what are they doing, and the consequences. And trade secrets is a hard area because, and Michael has pointed to this too, that one of the things that we need most is not more statutes to defend the trade secrets, but we need more research, more empirical studies on how these lines matter, and there are reasons why there are less empirical studies because it doesn't have that paper trail that patent law has, so it's really hard to study. But I guess what I want to say is that again, to remind us that just studying what's going on in courts is really not enough, that there's much more beyond that, and so I think that there is actually good empirical data about how changes in the law actually affect mobility. So there's a forthcoming study actually by Wharton researchers that look at trade secret changes in doctrine, and they look at the inevitable disclosure doctrine in terms of mobility and also the filing of patents, and their study that will come out is actually interesting because they see that there's, with the increased protection of trade secrets, there's not only less patenting activity, but a decrease in the quality of those patents. And when they compare different areas of patents, they actually conclude that it's not so much that employers are choosing to protect trade secrets rather than patent. It's actually, they're looking at the decline of innovation incentives by employees. And so that's something to keep in mind, that again, that effect of silencing and changing activities. I'll say two more things. One about the whistleblowing effect, so, or the whistleblowing protection. So I mentioned at the beginning that I thought that was a good amendment to the Trade Secret, to the Defend Trade Secret Act, but I do want to also emphasize that it in itself is a limited immunity, so it only establishes immunity when there's a direct disclosure of a violation of a law to government officials or to an attorney under seal. And so it's very narrowed in scope and things that the public clearly have a right to know, but are not illegal or outside of that scope. And exposing illegality to the media. I've done a bunch of research on whistleblowing behavior. A lot of times that's actually the first stop, especially if we're talking about public sector or public or private contractors for the public sector. So all of that's not covered. And you know, we can also think about that in the context of NDAs with the Me Too movement and the kind of effects on reporting harassment. So it's not disconnected. So I guess I'll just say I agree with Michael that we need more study, but I think that we should have this stance because of the inherent threat that trade secrecy poses in enclosing information without a lot of knowledge of that, how it affects innovation, and because of its strength of enclosing knowledge, not just to be used but also to be known. I think our default should be to not write more tools before we know more about these effects. Thank you.
I think we've got a little bit of time, so questions, if you guys don't mind, if you don't, just so there's a disembodied, voice to the answer to the question on the video. Any questions? It's Rob.
So, really appreciated both your talks. I would like to ask you about evaluation. There is very little research that's been done so far on trade secret valuation, and such research as has been done has primarily been on the criminal side, the EEA prosecutions from 1996 forward. So the enforcement discretion, there's the evaluation that you have to do as the prosecutor to figure out, is this worth going after? And then finally, at the end, what value do you assign to it for purposes of sentencing? That's the subject of a couple of studies. And then there are, scattered few UTSA studies that don't really, they have small ends and, not a lot to say. Do you think that the existence of a federal cause of action and the fact that it's civil now, so yeah, we'll still have selection effects, but maybe the private incentives will give us a greater diversity of data from which we can draw more causal conclusions?
Well, first I'll say that the census has a study from 2009 on trade secret value and investment that's worth looking at. The second is, I think the answer is no. I think it's hard to measure valuation of trade secrets in litigation. It's not like a patent where you have a single thing that you can measure, because there are so many trade secrets that we don't know about by definition. And so you might have one secret that's really important, but we don't know if somebody else has a similar secret or a different secret or a bigger secret or a smaller secret. So you could get some information on, for example, how a customer list is valued, I suppose, but I think more generally, I think it'd be pretty hard. I'm sure somebody who's creative could come up with a methodology, but I'd be skeptical of it myself.
I have a lot to add on that. I think it's really hard to. I think there's a lot of numbers, like the census report, but I think Rochelle and I in our paper we questioned some of those numbers because I think a lot of times there's kind of an over valuation of because it's self-reporting, so they want to say, companies want to say we have these super valuable trade secret portfolios, and we need a more independent measure. So, case law study can provide something, but it will be a very narrow part of the world, trade secret world.
Ted and then Rochelle.
So I have a question going forward. So now we have two tracks, so it's state and federal law. Whereas in other areas of IP, we can have one track, federal, or there's unfair competition in other state causes of action where we don't have federal claims. So do you think we should supplant state law entirely and just go to federalized trade secret law? Or are there reasons to retain both?
So, it's interesting because there's some, in some ways, there's some sort of, there was hope in when we looked at the language of the Defense Trade Secret Act that some things didn't really get codified into the act, some types of information. So there's some, and I want to know more about this, that there was some kind of bargain with the entertainment industry that really didn't want the law of ideas to be part of that. And when you look at the language, sort of that would be carved out, but that would still exist in state law. So there would be, you know, and each one of the things that I'll point to, just using your question to get me back to this, is that Michael said, you know, plaintiffs always overclaim, defendants always underclaim, but the fact is that there's plaintiffs and defendants are patterned of who they are in these lawsuits. You know, it's usually employers on the one side and you know, employees on the other side, or you know, kind of foreign. So in that sense, like in Hollywood, there's going to be companies that can say, oh, we have everything we need with the Defense Trade Secret Act, but what about individual inventors, you know, creative people who actually want things that are not covered by the Defense Trade Secret Act to still exist. So that's sort of one thought of how it matters in different industries and in different contexts, what maybe the state law still provides. I'll let Michael and
Just a couple of points on that. From an access to justice point of view, I like the idea of being able to file something in state court, not have it, although I guess if you file DTSA in state court against a non-diverse, it still needs state court, so that's not that important. I think the UTSA and common law, trade secret, case law is big enough that you don't want to see that go away. But my prediction is that in 20 years, state trade secrets will go away, state trademarks.
Yeah, my question's for Michael. So you had said that you were more worried about patents because patent cases are almost always against people that had no idea it was coming. They were independent inventors. So one part of this is, I didn't even know that's true. It's not what I would have thought from reading cases. I think it's often two very large companies, one of whom was trying to invent around and maybe do it all that successfully. So that's one part of it. And if I were worried, I would not worry so much about whether you knew it was coming or not knew it was coming. I think the relevant thing to worry about is how sophisticated defendants are. And I think in a lot of trade secrecy cases, it's employees. They have no idea whether or not they've committed a violation. And so the number of filings is irrelevant as compared to the number of threats. Whereas in patent cases, it's the filings that we care about. So you seem to be comparing apples and oranges, and I'd like to know a little bit more about where you get your statistics.
So sure. So on the second point, it's true, although many employees that get sued are usually now employed by another firm who winds up defending them or getting them their own counsel.
If they've changed jobs.
Well, that's right, although I don't know how often people get sued civilly when they haven't changed jobs.
No, I'm worried about people who don't change jobs because they've been told that they're going to be sued civilly.
Well, that kind of an effect is definitely an issue, and I don't disagree with that.
Another effect, I'll just add, is the particular loss to entrepreneurship. So and we have evidence on this that when they leave, they'll leave indeed to a bigger, established competitor, but not start their own company. So that's
That's right.
why we have that
Yeah,
imbalance.
I'm aware of all that. I mean, I represent clients, with all these circumstances. I understand all that. So, yeah, so I agree. Yeah, on the second point, I agree. On the first point, there's studies on how often willfulness is argued, for example, et cetera. Some people take issue with the studies and think they underrepresent, but but most, that willfulness is not actually alleged all that much until the first demand letter is sent, for example. So there's pretty good data on that.
Willfulness is you knew that you infringed, right? If you have a
Yeah, but
decent defense that you were inventing around,
But yeah, but the plaintiff's going to allege it if they have, right? I mean, it's not who wins, it's what they're alleging is the argument. And like I'm saying, there are folks who think that that methodology understates how often. I'm actually one of those critics. But, if you look at 60% of litigation being NPU litigation, it's not big companies suing big companies. So there is plenty of big companies suing big companies where they know exactly what's out there. But in my research and in talking with folks at companies, that most of the time they don't do this kind of patent search. They don't know about the patents.
So we've got a thing to get to drink and. That's where I'm at, sorry.
You gotta have priorities.
Priorities, right. But we always have, you have to remember when you were an evil twin, because you're always an evil twin in our heart. So we have these parting gifts for you all. Thank you so much, Orly and Michael.